910, Big 550, KTRS. You should hear the things I don't say. Well, welcome back, Big 550, KTRS. It's time to go to school. Professor at St. Louis University Law School and KTRS legal analyst. Good morning, Greg Willard.
Good morning, McGraw.
I hold in my hand a list, not all of them, but some of the more interesting Supreme Court cases that they're going to be taking up in this next session. We'll get to this in a second. But I want to throw you a curveball here.
Okay.
Have you been watching Ken Burns' Vietnam War?
I have.
How good is it?
Breathtaking.
Is it not?
Breathtaking.
Yes.
It's one of the most remarkable pieces of television, film, journalism that I have ever seen, McGraw. And I'm sure for millions of Americans, it brings back some memories we're not particularly happy to bring back.
Sure.
But it is just an extraordinary piece.
For those who don't know, you were sort of in and around that White House world at that time, or right? I guess as it was ending.
As it was ending, I was President Ford's White House staff assistant, and so was there there at the end of the Vietnam War. And my wife Annie was a little closer. She worked in President Nixon's White House, and so of course she was, shall we say, right in the thick of it.
What's amazing to me, I only know it from movies. Oliver Stone movies, history books, things like that. But they take you have audio of Lyndon Johnson and Robert McNamara saying, we can't win this war. I don't want to get bogged down. There's no reason for it. The American people won't stand for it. What should we do, President? Send another 100,000 troops.
Let's hit that. Let's hit that vaunted 500,000 mark.
Right.
Really?
A 500,000 troops.
Wow.
In Vietnam, and it was all. Ho Chi Minh, according to the documentary, only picked Russia because that was a partner who would fund him to get the colonials out of his country.
Right. I mean, as you may recall in the opening, I think it was the opening segment, McGraw, they pointed out that Ho Chi Minh's original manifesto, the opening lines were from our Declaration of Independence.
Right.
Who knew?
Yeah.
Wow.
Yeah. Was it that obvious at the time? Was it, because we're watching it over a couple of hours. This happened over years, so it was a slow-motion disaster.
Well, as I remember the 60s and 70s, I was a young person at the time and had to register for the draft in those days.
Right.
I think the short answer to your question is no, it wasn't clear at the time for many of us, and I think part of the reason it wasn't clear, and Burns captures it well, is it wasn't whether the Vietnam War was a good thing or a bad thing. It was, well, we need to support our president and America's right, as in correctness.
Yes.
And
no matter what. My president will never lie to me.
Will never lie to me.
Never make a wrong decision.
And we would never go into a war that perhaps in retrospect we should not have. And so I think for millions of Americans, and I am here to admit, myself included, I think our perspective of that horrible conflict was clouded.
I also think that watching the world today with the protesters, the peaceful protesters, the violent protesters, the animosity towards our president, the full acceptance of whatever my leader who I agree with will never lie to me, we're looking at ourselves.
Well, we are looking at ourselves, and I think another point you point out the recent protests here in St. Louis, and I'm certainly not going to take sides on any of those issues, but I think the Burns documentary points out a remarkable contrast in terms of protest. Compare what has happened, say, downtown Monday night before the Cardinals game with the Democratic National Convention in Chicago in 1968.
Yeah.
And again, I'm not taking sides, but the civil discourse and the civil protest in 2017 as compared to what many of us remember back in the 60s is quite a remarkable difference.
Interesting stuff. All right, let's get to it. So Greg Willard, KTRS legal analyst, but I still want to get you on. You told us a little tease for the next segment, or the next time you're on, one of these times on a slow news cycle. I want to talk to you about what you've talked to Gerald Ford about. He was on the Warren Commission that investigated the John F. Kennedy assassination.
He was. He was the last living member, McGraw, of the Warren Commission, and from a personal standpoint, very difficult because he and Jack Kennedy came into the Congress together in 1948.
So, and you've had extensive conversations with him. We'll get to that at another time. But let's talk about the Supreme Court and their upcoming what do you call it, session?
This is the new term, the first Monday in October, as it's iconically referred to, and it will begin this Monday.
And one of the big ones, I think, is the gerrymandering case, which goes to all of the things we're talking about. And what is the Supreme Court going to decide about the gerrymandering case?
Your characterization is terrific. This could be a game changer,
yes,
to use the phrase. Set the stage, McGraw. The case, the Gill case, comes out of Wisconsin, and it's partisan gerrymandering. Think about it this way. We have a state that has 1 million people.
Okay.
Half of them are Democrats, half of them are Republicans. The Republican state legislature sets the boundaries for 4 districts, shall we say.
Okay.
And they through big data and otherwise, they set it up so they have 3 of the districts will be Republican and 1 will be Democrat.
Right.
And they are very effective at that. They call it packing and cracking. Mm-hmm. And so we have it in Missouri, for example. If you were to look at how many Democrats or independents leaning Democrat in Missouri and Republicans and leaning Republicans, it is nowhere close to the makeup of the General Assembly in Jefferson City. So the question the Supreme Court is going to have to answer is whether partisan gerrymandering is unconstitutional.
Now, they've had this argument since the beginning.
Goodness. Well, the phrase gerrymander comes from Mr. Elbridge Gerry, one of our founding fathers. And so it goes back to the founding of the Republic. We can all agree, McGraw, that legislatures can't draw, as they sometimes would, unfortunately, in our history, lines to disenfranchise minority voters.
Right.
We all can agree on that. It's a violation of the 14th Amendment. What the Supreme Court, as you point out, has wrestled with is this next level of partisan gerrymandering. There was a case several years ago called the Veith case, and it was 4-4-1, Justice Kennedy, and basically the court said, you know what, we're not going to get involved. It's up to the legislative branch and the president to figure it out, or the state legislatures and the governors. Well, it's now back.
Right.
And so I think most of the pundits are saying that it still looks like it's going to be 4-4, and Justice Kennedy will be the decider. And the question is this, McGraw. If the court is going to wade in and start calling balls and strikes with partisan gerrymandering,
right,
what is the test? What are the criteria that are to be used? That was what gave Justice Kennedy pause in Veith.
It isn't a liberal or conservative argument per se, right? I don't think there's a conservative philosophy over gerrymandering and how you do it. But but it currently is helping Republicans because they have the majority of the state houses, the majority of governors. They're the ones who draw the lines. And so therefore they have more Republicans in the House, and it's harder for the Democrats to sort of take control.
I'd put an additional spin on it. It's helping Republicans more because, as you say, the Republicans control more state houses.
Right.
But let there be no doubt, the Republican apparatus and the Democratic apparatus, they are both fully capable of packing and cracking partisan gerrymandering.
It's because Lacey Clay, realistically, he's up for re-election every 2 years. Mm-hmm. But realistically, the man cannot lose his seat.
He has a safe district.
Right. Anyone who tries to run against Lacey Clay cannot win because he is so packed with Democrats.
Or Billy Payne in Southwest Missouri. But again, you could, with this packing and cracking, you could draw maps that would have the Missouri delegation in Congress be substantially all Democrats.
Right.
Because it's the statewide mix. And so it's an equal opportunity in terms of both parties.
They draw the lines to give, the fact that Ladue is being represented in Washington, D.C. by Lacey Clay is comical. but that's how they draw the lines so that they get enough Republicans and enough Democrats to appease the court rulings, but also to make sure Ann Wagner's seat is safe. And the only really fight or re-election is the primary.
Well, the only real fight is the primary, and then the really big fight is the election right after the census. Because then
they're the ones who get to
draw.
But
what we're going to hear in Gill is that in Wisconsin, you have basically a 52-48 split between Republicans and Democrats up there, but 2/3 of the Wisconsin House of Representative seats are controlled by the Republicans.
Right.
And so has it gotten to the point, this partisan gerrymandering, packing and cracking, that it is unconstitutional?
So what would, and I know we're taking too much time, but this one I think is the whole ball game. What's the alternative? To draw every district as close to 50-50 as possible, or not? I mean, we can all play with numbers any way we want.
Well, I think to go at the full end of the spectrum, McGraw, the alternative is to let a computer do it, blind as to political affiliation, and just sort of let the chips fall where they may.
Right.
Relatively contiguous and relatively square districts.
Or Missouri has 8 districts. You just draw the lines, 8 districts. You draw it
randomly,
like a map and like a checkerboard, and
randomly
say, here are your 8 districts, and so be it.
So be it. And but I don't think we're headed towards that, and I think that's why Justice Kennedy is struggling. Is if the court crosses that line, what are the rules and what are the criteria? And he may say there's no articulable standard, therefore I'm not going to involve.
I think this is an impossible case.
Extremely difficult, and as the saying goes, you wouldn't want to be Anthony Kennedy.
Yeah, holy mackerel. All right, we got that one. Now, this other one's kind of interesting as well. Voter rolls and purging of voter rolls. This is another one that's interesting.
This is a tough one. And again, history matters.
Yes.
And what the situation here is a case that comes out of Ohio, and you have the real world situation where people move, McGraw.
Right.
And should they remain on the voter rolls? So John Smith moves from Ohio to Oregon, and he didn't take his name. Or it's still not having been taken off of the Ohio rolls. So the Federal Voting Rights Act has a prohibition that you cannot be removed from the voter rolls simply because you haven't voted. You haven't exercised your franchise.
Okay.
Voting rights said you can't do that. Well, what Ohio has done is if somebody hasn't voted, Ohio sends them a notice and says, we note that you haven't voted. Do you still live at this address? If they don't get a reply, they take the person's name off the voter rolls.
Okay.
The plaintiffs in this lawsuit have said, wait a second. You're taking people off the voter rolls simply because they haven't voted, because you don't send that notice to people who have voted. Well, obviously, because they voted.
Right.
And so it's just a ruse to get people off the voter rolls.
Right, because we want our voters to vote. We don't want your voters to vote.
Right, and we think that your voters are more likely not to respond, and therefore we go through this process. So the Supreme Court is going to have to decide it. Unfortunately, we as a nation have a very sordid history of trying to squash the franchise.
When I got out of college, I stayed with my sister down in Scottsdale for a couple of months, and it just so happens that I was there for an election cycle, and I registered. This is 1990. She is still getting postcards. Don't forget, I'm McGraw Millhaven. Here's your voting booth for 2016, which is ridiculous.
And that's what the state of Ohio would say is, Houston, we have a problem. We have a problem here, and we need to maintain as best we can the sanctity of the voter rolls.
All right, let's get 2 more in here. Cell phone tracking and privacy. This is a good one.
This is a tough one, and it's going to be a particularly tough one for Chief Justice Roberts. So, the Fourth Amendment protects us from unreasonable searches and seizures. So the police just can't march into your house, McGraw,
Right.
seize property.
Right.
The Supreme Court long ago has said that doesn't apply under the so-called third-party doctrine to bank records, for example, or a phone call list. Information that you voluntarily or reasonably voluntarily have given. So you've given your bank information to your bank, and the law enforcement doesn't need a subpoena, a search warrant to get that. Now, what about the tracking logs for your cell phone? And what happened, Mr. Carpenter, who was convicted in this case, Mr. Carpenter was committed a series of bank robberies. And so what the law enforcement did is they went to the cell phone company.
Yeah.
And they tracked the location of his cell phone during the robberies, and they were able to connect the dots. He says that violated my Fourth Amendment rights. That's an unconstitutional seizure. And so the court is going to have to decide, and Chief Justice Roberts has been very troubled about how do we apply a 1700s Fourth Amendment to cell phones. And so the question is,
as a strict constitutionalist, that's an interesting question for him.
That will be a tough one, my friend. And so, but the tipping point, I think, McGraw, is on this third-party doctrine is whether your and my cell phone location information, whether that's like my bank records, or whether that's something closer to what information inside our house.
Yeah.
And it's going to be, I think, a tough question in and of itself, but it's going to be a bigger question, as you say, in terms of just modern day life and technology in our society.
One more here, and then we'll let you go. Greg Willard with us, law professor, going over highlighting some of the interesting cases that the Supreme Court is going to start taking up. Let's go with sports betting. I didn't know there was a federal law that only allowed gambling in Nevada.
There's a federal statute that grandfathered in 4 states, Nevada, Delaware, Montana, and Oregon. And then it gave New Jersey 1 year to pass a statute.
Okay.
For whatever reason, New Jersey did not take advantage of the 1 year. And then I think they had sort of a whoops moment and said, oh, golly gee whiz, we want to get back in the game. And so they've been trying to get back into the game of sports betting for several years, and this is part of their latest attempt. This case, this New Jersey case, is one that probably only law professors could enjoy. It deals with the 10th Amendment to the Constitution.
Which one's the 10th?
Yeah, exactly, my friend.
Remind me, that's not a biggie.
Well, what it in effect says is whatever power is not granted to the federal government under the U.S. Constitution or specifically retained to the states, whatever is sort of left over, the states get to keep that.
Right.
They retain that power. And so it for many years it has sat there relatively dormant, and then occasionally the 10th Amendment will raise its head, and then it will go back into the ash heap of history. Well, suddenly Governor Chris Christie and his friends in New Jersey have resurrected the 10th Amendment to be their champion to allow sports betting in New Jersey. And we will see whether they can prevail and say we have a retained right in New Jersey under the 10th Amendment, or whether Congress can say, nope, sorry, Chris, no sports book in New Jersey.
There you go. That's some of them. Okay, last question for you. I know I'm late, but one more. We had a caller call up the other day who said, all this. I'm a baker. It's against my constitutional right to bake a cake for a gay marriage or whatever.
Yes.
Somebody called up and said, "Hey, is it constitutional for a bar to say I refuse the right to serve anybody?" You know those signs that say, I reserve the right to not serve you.
It's not so much a constitutional question as it's the Federal Civil Rights Act, and you can refuse to serve certain patrons for certain reasons. So if a patron comes into a bar clearly inebriated, absolutely appropriate not to serve that patron. A minority person comes in and the proprietor says, I'm not going to serve that person because I don't serve minorities.
Right.
That's a violation of the Civil Rights Act.
So even though the sign says we reserve the right to refuse anyone, within the law.
Within the law. That's
basically.
a good way to put it, McGraw. Yes.
That is a credit and a half of free education here. You are well on your way to a law degree at St. Louis University. Greg Willard, always a pleasure. Good stuff. Talk to you soon.
Great to be with you, my friend.
9:30.